Join us this week for a very special edition of Misstrial, where we're going to be joined by none other than my co-host on my other podcast, LegalAF, Michael Popok. Okay, who doesn't love Popok? So he's going to come and join the ladies of Misstrial, and what we're going to talk about is this huge document dump that Jack Smith is planning to do in Washington, D.C. on Thursday, on the day that Misstrial airs. And so we are going to bring it to you so that you can see a breakdown from Danya Perry, Kathleen Rice, myself, and none other than Michael Popok, the great lawyer that we all love. And I am honored to call my co-anchor, co-host, and partner in crime. So what we're going to talk about is that case, right? The Washington, D.C., United States versus Trump in front of Judge Chutkan, where the special counsel has asked for permission to file 180-page or greater than 180-page motion to support their presidential immunity claim, and why it is that the new superseding indictment brought by the special counsel Jack Smith is not, the new superseding one is, he's not immune from the conduct in there. And so he wrote basically a request or a motion to the court to file a brief that is larger than necessary. Okay, it's government's motion for leave to file an oversized motion. That's what he called it. It was a 3-page letter or motion that he wrote to the court, and basically said, look, we know that normally you can only file a motion that's 45 pages long, but we need more space here, and here's why. And Jack Smith, the special counsel, did a great job really showing why he needed it by quoting the Supreme Court of the United States over and over and over again, right up front, straight away, saying that the Supreme Court emphasized the, quote, necessarily fact-bound nature of the immunity analysis, determining whose characterization may be correct and with respect to which conduct requires a close analysis of the indictment's extensive and interrelated allegations, said Smith. So he goes on to quote the Supreme Court, the analysis must therefore be specific and may prove to be challenging. So knowing, for instance, what else was said, contemporaneous excerpted communications, or who was involved in the transmitting of the electronic communications and in organizing the rally could be relevant to the classification of each communication. So these are all quotes that I'm taking from Jack Smith's letter that he took from the Supreme Court. He said, look, the Supreme Court remanded to this court, meaning in front of Judge Chutkan, in the first instance, to determine, with the benefit of briefing, so basically, essentially, whether the defendant's conduct in this area qualifies as official or unofficial. And the Supreme Court, if you remember, in July when they came down with the presidential immunity decision, really chastised Judge Chutkan for ruling, and frankly, significantly chastised the D.C. Circuit, the appellate level above Judge Chutkan, for not developing a factual record, for basically, essentially accusing them of glossing over presidential immunity. And so what they said was, you got to develop a factual record. You got to make a determination of which things are core presidential duties, like things that are in the Constitution that he would absolutely be immune from criminal prosecution for, what falls in the category of non-immune because it's not presidential, right? Things like paying a porn star, maybe paying off a porn star hush money, that kind of thing. And then this in between presumptively immune category of cases, or category of conduct, I should say, that talks about things that could be presidential that but might not be, and that it was unclear based on the record here. Things like conversations with Mike Pence, right? It could be based on doing your job as president and vice president and then would be immune, or it could be as candidate for President Trump and candidate for Vice President Pence, and then you're just any other person seeking an office and not immune. You're a private citizen. So Jack Smith did a great job using Supreme Court's words really to support their position up front, and essentially said, look, to fulfill the remand directive from the Supreme Court, we're proposing to open this brief up with a discussion of and description of both pled and unpled facts, so meaning facts that are in the indictment and facts that are not, so that all parties and the court knows what it needs to consider in order to make its fact-bound determination. So that is required by the Supreme Court. So the government said it would have a substantial number of exhibits, and the court will make determinations in the first instance that will be subject to an appellate review, because of course this presidential immunity, whether you're immune or not, gets reviewed by the appellate courts up to the Supreme Court. Either side can appeal that in the middle before we even go to trial. So Jack Smith points that out and says, look, this is going to be subjected to exacting appellate review. And so he says, look, so therefore you need, the court needs a record to support the determination, and they want to submit a comprehensive brief, and therefore they're asking for permission or seeking leave to file more than the 45 pages, and it's going to be about 180 pages. They said about half is a detailed factual proffer, which means they're going to put forth their facts with extensive footnote citations to an exhibit appendix that's more than 30 pages long. They also said, look, there's a substantial amount of sensitive material. That's a term of art that was defined in the protective order that Judge Chutkan issued with respect to materials, and said, look, that stuff that's sensitive material, that's defined by the protective order, we will file it under seal. So we will have both a redacted version and an unredacted version. And then Trump replied 2 days later, saying, nothing to see here, no need. We don't need you to file 180 pages. And let me read just some of the language. They put in their 9-page response to this request for the ability to expand to 180 pages. He said, this is unprecedented and irregular. The nature of the office's approach to quadruple the number of pages. They didn't even cite any authority as to why they need this. P.S. They did, because they cite to the Supreme Court in this very case that said you do need to do this. So that was the authority they cited to. But they're saying there's no authority, basically saying, since there's new law, there's only one presidential immunity case, so there's no other cases saying, yes, in a presidential immunity case, you can expand the record. That makes sense because this is new law that the Supreme Court created just for Donald Trump. And they did cite to that case. Anyway, so they say this is fundamentally unfair. It creates a closed record for addressing unfiled defense motions by crediting their own untested assessments of purported evidence, denying President Trump the opportunity to confront their witnesses, and preventing the defense from obtaining discovery. We can't cross-examine the discovery. We can't get the discovery. It'll taint the potential jury pool. It has bias and potential witnesses. And they're also objecting to the fact that Jack Smith gets to file a surreply, meaning after they go, Smith goes first, Trump files their reply brief, and then the government gets to file a reply to the reply called a surreply. They're saying that's a politically motivated opening brief. It's an improper special counsel report masked as a superfluous filing seeking an advisory opinion on a criminal case, which is highly unusual. I mean, they're really throwing a lot of kind of bombs into their motion. They're saying the document violates the presidential immunity doctrine. It taints the integrity of the proceeding. It increases the First Amendment and harms from the gag order, and it also violates the DOJ manual. And then they kind of mock Jack Smith by saying the court does not need 180 pages of, quote, great assistance from the special counsel's office to develop a record necessary to address presidential immunity. When Judge Chutkan fires back, you will be sure that she will be the one to say, don't tell me what I need and not need Mr. Trump. That's for the court to decide. They also say things like, there's no need to litter the docket with an unnecessary tome. I mean, it's just, give me a break. So anyway, they also said, but if you are going to grant it, then to file a big brief, then we also want to be able to file a big brief in response. We want to be able to file more than the 45 pages, the 25 pages, which is what the reply normally has to be. And also, P.S., we want a sur reply after the government. So anyway, one of my favorite quotes is, "These defects in the prosecution arise from, among other things, the absolute nature of immunity, the immunity attaching to the office's allegations relating to the Vice President Pence, and, quote, serious questions regarding whether the Attorney General has violated that structure by creating an Office of Special Counsel that has not been established by law that must be answered before this prosecution can proceed." And they cite to Trump v. U.S. in this case, where in the concurring opinion, they cite to the concurring opinion of Justice Thomas, who essentially called out the special counsel in the first place and saying that Jack Smith is illegitimate. You can't have a special counsel. It's not provided by statute or by law. And that's what Judge Cannon in Florida based her dismissal on that concurring opinion in this Washington, D.C. case, right? Because it went up to the Supreme Court, the immunity decision. And if you recall, Justice Thomas decided on his own to just be like, by the way, even though this issue isn't here before the court, I'm going to concur and I'm going to say, clearly talking to Judge Cannon in Florida, that special counsel is invalid and illegitimate. So they cite to that, and they actually cite to Judge Cannon multiple times in this 9 pages, over and over again, about how this is how it should be done, and special counsel is illegitimate, we haven't received discovery, this is a monstrosity that they want to file, and that in Florida they came and they asked for a gag order in that case because Trump could pollute the jury pool, but now they're polluting the jury pool. This is a premature special counsel report, on and on and on about Florida, and Judge Cannon, and clearly they are panicking over this, even though a lot of it's going to be under seal. They are literally panicking. They don't want this out in the open. They don't want any of this information. It's not the mini trial that we've talked about many times on Misstrial and on LegalAF. It's just a brief that justifies and explains why certain conduct charged has nothing to do with being president. It has everything to do with being a private citizen or a candidate for office. So please make sure to tune in on Thursday for this wonderful new mashup crossover episode of Misstrial and LegalAF with Michael Popok, who's going to join us, and we're going to talk about all in detail what is going to happen, what is happening, and what Judge Chutkan is going to allow, and what all this evidence is that Jack Smith is going to drop on the court. So be sure to tune in. I'm Karen Friedman-Agnifilo, co-host of LegalAF with Ben Meiselas and Michael Popok, as well as co-host of Misstrial. And I look forward to seeing you on Wednesdays with LegalAF and on Thursdays with Misstrial.
In collaboration with the Midas Touch Network, we just launched the LegalAF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at LegalAF MTN. That's at LegalAF MTN.